And if everyone, good morning. If everyone could please mute your Zoom, that would be wonderful so we don't get background noise. Good morning and welcome to today's event. I'm Kathleen Rose, a member of the CRCBR Education Committee. I hope you all plan to attend and participate in the upcoming Core Concepts series beginning February 1st. This is open to both CRCBR members and non-members, including members of TCAR. These courses are intended for those either relatively new to commercial real estate or experienced brokers wanting to learn more about a specific area. We've got some great instructors and teachers that are leaders in the industry, so it would be worth the time for sure. You can register for the entire series or just a single class. For more information, visit crcbr.org. Finally, I'd like to thank our co-host, TCAR, for making events like this one possible. And moving on to today's conversation, NAR's Missouri antitrust verdict. I would like to present today's speakers. John Waite is a partner at Martin and Gifford, PLLC, and general counsel to the North Carolina Realtors. And Michelle McCaskill is vice president of risk management and assistant general counsel with Canopy Realtors. John and Michelle will each give you a brief introduction of themselves. And John, I will turn it over to you. Thank you.
Yeah, thank you very much. Appreciate it. Glad I could be here with you all. We're going to go over sort of the nuts and bolts today of the Burnett case that came out of Missouri. And I'm going to share my screen with you guys and bring up handy dandy PowerPoint I made for you. All right. All right, so starting just with a little bit about myself, because I think some of the context about myself will be helpful for the rest of my presentation. John Waite, Martin and Gifford. Martin and Gifford, we're a law firm in Winston-Salem. We're general counsel to NC Realtors, and so we do a lot of work for them. We do other work too, like defending agents, the Real Estate Commission, representing some real estate firms and brokerages, but we are pretty much dedicated exclusively to the real estate brokerage industry. We do a couple other things, but that's pretty much what we're focused on most of the time. I have two partners, Adam Stallings and Bill Gifford. Some of you may know my old partner who just retired, Will Martin. And, I'm basically the slightly dumber, better looking version of him over here at our firm. So let's get into just what in the world does antitrust mean? Because after the Burnett case came down, I had a friend who was a realtor, and I was talking to her about it. And it was like a close friend I've known for a long time. And so I was out to dinner, mentioned it to her, and she was like, antitrust? You mean like trust in states? And I was like, no, I do not mean trust in estates. So let's talk a little bit about what the word antitrust even means before we go anywhere else, okay? Antitrust, really, we're going to be focused on federal law. There's also mini antitrust statutes. North Carolina has its own statutes regarding antitrust, and it really regards to these two things. You may have heard of maybe one of the most famous mini claims in North Carolina would be unfair and deceptive trade practices, which I'm sure lawyers love to throw at you guys when they want to scare you. And it's because it is kind of scary. I'm not going to lie. So if you get something like that, talk to your lawyer. Okay. Don't even mess around. But the Sherman Act under federal law basically has two main things that it says you cannot do in the antitrust context. One, restraint of trade. Restraining trade means exactly what it sounds like. And we're actually going to talk more about that today with respect to you guys in commercial than in a little bit different way than they did even in the Burnett case in Missouri. And then number two, it prohibits monopolies. Okay, monopolies are a little bit more famous, and some of you may have heard of some of these cases. I just brought up a couple of them. One that's not up here actually is from just a couple of years ago. You may remember, maybe 20 years ago, maybe 15. It was really hard to get other browsers to work on your computer, not Apple's. This dealt exclusively with PCs. And the reason for that is because Microsoft was, putting code into Internet Explorer to make sure that other Internet Explorers could not work on your computer. Okay, so that was a restrainer trade and a monopoly. Both they in some cases fall into one category, some cases fall into the other, and some of them fall into both. But the Microsoft case from a couple years ago is something even more recent. But if you are familiar with Standard Oil used to be one company, and that's, they don't call it the Rockefellers for nothing. The Rockefellers own Standard Oil. Basically, all these companies that you see listed after that got broken up. Standard Oil got broken up into those companies, but they used to all be one company. So you can imagine that when you've got that much power, then you can create a monopoly to control prices and to unfairly hurt consumers. And that's really, I don't want to run past that, because not all monopolies are unlawful. Only certain monopolies are unlawful. Who decides whether a monopoly is unlawful or not? The courts do. So we're going to try and give you some guidance today on how to avoid becoming one of those, but that ultimately, whether a restraint on trade is lawful or not is going to be up to the courts. And then another example I have up here is AT&T. I like to bring up this one because my uncle worked for AT&T before it got broken up, and it was kind of interesting watching him, as I was a kid, watching him sort of navigate these waters as, his company they used to work for got broken into a bunch of different things. And interestingly, his main job used to be working on payphones, which I think is such an interesting job now. But it's just, I mean, my kids have no idea what a payphone is. I'm not even sure they've seen one. Anyway, so when we're talking about antitrust today, this is what we were talking about. We were talking about restraint of trade primarily today, but also remember that it includes monopolies. And I'll come back to that in a little bit. So what happened in Missouri? The case is called Burnett versus National Association of Realtors. There's a lot of other people named in that, including some MLSs and some brokerage firms, large brokerage firms, not small ones. And I think it's really important to phrase what happened in this case this way, and that is nothing special happened. There was nothing here that was like earth-shattering, some sort of special anomaly. It was just a standard residential real estate transaction, or actually there's several plaintiffs, so we'll say transactions, okay? And it's, for those of you that are familiar with the residential transaction and the way it typically goes in the context of an MLS, sellers hire a listing agent. Listing agent put their properties in the MLS. As part of listing the properties in MLS, they offer to pay cooperating compensation to the buyers, and then those to the specifically to buyer agents. And then buyers made offers on the property. The buyer paid the money for the transaction, and then out of the seller side, listing agents paid. Listing agent then shares compensation with the buyer broker. The sellers in the Burnett case sued, saying that the MLS and the way it operates created a restraint on trade. Okay,
that kind of stuff. I mean,
it's
it's
specifically like a conspiracy.
yeah, he makes a big deal out of that.
Okay, did we get muted there? All right. So what the seller sued, saying that this was an illegal, unlawful restraint on trade. Okay, and I'm going to talk more about this, but a really important thing that happened in this case is prior to the trial, the judge entered an order that said that the MLS mandatory compensation rule, if you touched it in any form or fashion, whether you are an MLS, whether you're a firm, whether you were a listing agent, buyer agent, if you in any way touched that rule in the MLS, then that was going to be a per se violation of the Sherman Act. What does a per se violation mean? Per se means automatically, no analysis, no any further discussion about it. If you're touching it, it's like, think of it as the plague. You are going to be infected with liability from this antitrust case, which is a very, very important ruling. I'll get to more about that in a minute. But prior to the trial, that's what the judge said. That was a judge decision, not a jury decision. But the way it works, for any of you who've been through a jury trial, probably not many of you. I've litigated probably 4 or 5 of them. I've actually sat on a jury one time. That was interesting. But the jury, they got all this, and they get the law from the judge. The judge reads them the law, and then what they have to do is apply whatever facts they've heard during the case, and they determine what the facts are. That's what juries do. If there's a dispute about the facts, then the jury is supposed to resolve those disputes. And so the jury decides what the facts are and applies those facts that they've decided to the law that the judge gives them. And in this case, because what the judge gave them was essentially a per se violation instruction on what the theory of liability was, then they went and deliberated. The deliberation was less than 3 hours, and they came back with basically everything the plaintiffs asked for, which was $1.8 billion. Under the Sherman Act, much like unfair and deceptive trade practices in North Carolina, those damages are trebled, which is why sometimes you'll see the number of $5.4 billion. But you got to remember that lawyer fees and costs are added on top of that for total verdict or total judgment, I guess is a technical term. But anyway, lawyer fees and costs, is that going to be astronomical? I don't know. I can tell you that one of the invoices for one of the experts was $1 million. That I do know. So I don't know how many experts they had, but from the plaintiff's side, but understand that these plaintiffs' firms, they're taking these much like personal injury cases where basically we don't win unless you win. They had to go out, get out loans and pay for these experts ahead of time. Most law firms do not have the kind of moxie it takes to fund one of these cases themselves. Very few do. And even if they did, they'd probably still get a loan just because it makes more sense from a accounting standpoint. Much like, these rich guys like Elon Musk, they don't spend their own money. They go get loans and spend the loan money and then write off the loan money off their other assets. So, same thing for these sorts of law firms. They'll go do the same thing because it just works better for accounting rules. Anyway, if you're super rich, you should look into that. I wouldn't know. In any event, so these, this firm, this plaintiff's firm in Missouri, they went and they got this. Have they gotten any money yet? No, they have not. And so let's talk a little bit about why that might be. Well, actually, no, I think I got one more slide to talk about something else, and then I'll come back to that. Okay. Yeah, that's the correct slide. All right. So what evidence was presented to the jury before they went out and spent, less than 3 hours and came back with this eye-popping number? This is not all the evidence, but this is just some of the evidence. And when I say evidence, this isn't like, lawyers showing up to the courthouse with a file folder. Okay. We are talking about entire rooms full of bankers' boxes of evidence. We are talking about multiple experts. We are talking from both sides. It wasn't like NAR's lawyers were just sitting there doing nothing the entire time. The reason I'm focusing on the plaintiffs is because of the overwhelming weight the jury gave to the plaintiff's evidence. Does NAR have arguments to make? Do these firms have arguments to make? Yes, of course they do. I'm not going to get too far into that today, just because I think that if you talk to your lawyer and decide that you want to bank more on those defenses and those arguments, that is something you are perfectly entitled to do. I'm not here today to tell you what to do. I am here today to simply present a postmortem on this case, not a postmortem on the industry. I've heard people misconstrue my words on that so far. Not a postmortem on the industry. Not here to tell you that today. If you ask my personal opinion, I mean, people don't even like organizing their own closets. You got people out there paying astronomical sums of money for people to come in your house and organize your closets. You think buyer agency is going anywhere? I don't think so. I just don't. Anyway, so what evidence was presented to the jury? You had training materials. And there was, you may have heard about some materials from Keller Williams that was very problematic. I'm not putting up examples of that, but if I had to describe the examples, this is actually written in the training materials. These examples are not examples about selling your value to your client. These examples are of how to browbeat your client to death in order to get the commission rate that you want. Okay. I don't care who you are. That's not something that I'm going to recommend. You can either sell your value or you can't. And yeah, I will just say this. It was problematic. Those training materials. If you have training materials for your agents, then I'm going to say this repeatedly throughout this presentation, but you need to probably talk to your lawyer about about whatever materials you have that are training materials. We're changing materials at NC Realtors. We're in that process right now. So what else was presented to the jury? Minimum commission rates set by firms. Now, I'm not saying that, if you have some of these policies, you're automatically in some kind of hot water. You're not, but talk to your lawyer about them. Make a distinction potentially of what is your firm's minimum commission rate compared to your agents. If your agents are independent contractors, which means technically they should be in their own business, are you exerting too much control over what they do or do not charge? So, that's something you're going to want to talk to your lawyer about and parse out those two things. Maybe make a change, maybe you don't. But I can tell you that minimum commission rates set by firms for their agents was definitely evidence in this case. The mandatory blanket offer of compensation to MLS, basically what I mean by that is the MLS rule in itself was presented. And in particular, the fact that at least up until right before this case went to trial, NAR's position was that you could put $1 in there, but not $0. And they changed that right before trial. Why? I don't know. That didn't make any sense to me, but they did. I don't know what the difference between $1 and $0 is anyway, but that's a different topic. And then there's evidence about buyer agents steering their clients toward homes that have higher cooperating compensation. And I put this in there just because I don't think this is necessarily wrong in and of itself. However, you got to look out for your client. You got to do what's in their best interest. And yes, in a lot of contexts, especially for a residential buyer agent, you've got a contract with your agent that you're supposed to pay them a certain amount. Yeah, they can seek that amount from cooperative compensation in the MLS, but that doesn't mean that, that you're automatically going to get it. Your buyer is on the hook, at least in North Carolina. Missouri might have been a little bit different. There was definitely evidence of that in this case. So I bring it up just as something that you're going to want to examine as part of what you tell your buyer agents to do. And I think that applies to commercial and residential. And then I put this up here, right after the Missouri verdict. I mean, immediately right after, there was a lawsuit filed in Texas. There was another one filed in Missouri. There's one in California. There's one in South Carolina. There's one in Florida. They're all Ohio. I don't know all the places where these lawsuits have been filed now, but in the weeks following the Burnett verdict, $1.4 billion, that's going to bring, any good personal injury lawyer out from under their rock. And same thing with these antitrust lawyers. They're not much different. They're much more, they're just, I think you can think of them as like ambulance chasers, which much nicer suits. And I mean, much, much nicer suits, because this law is difficult and it takes a long time and the payoffs can be big. But I mean, these are the same guys that, go after, they'll sue Burger King because the burger doesn't look like it does in the commercials. Okay. These guys, this is what they do in any event. So in the Texas case, I thought these facts that they alleged were interesting, simply because I do think that it is if these are true, I'm not saying these are true. These were alleged in the complaint. These are not facts, but you only got 0.5% or less of sellers offer a buyer's agent below 2% in these big markets in Texas. And then a large majority of agents say they will not negotiate their commissions. As I said, your time has value. And not only that, if anyone were to ask me about what that time value of a commission means, it's not simply purely what your time is in that particular case, because how many transactions are you going to go through before you actually do receive a commission? You have to bake in that risk that transaction is not going to close at all. And that risk also has value. So for people who want to just view this as a straight up one-to-one kind of ratio with respect to commissions. I disagree with that very strongly, and I don't think it's fair to you guys that, people are armchair quarterbacking that, but just so you know, they are. Anyway, so that's what happened. That was some of the evidence. What about NAR's appeal? You've probably, if you've been tuned in at all, this is happening. Well, before you even get close to an appeal, and just so you know, my first job out of law school was clerking at the Court of Appeals in North Carolina here for a judge. I did that for a year and a half before I started my own firm. And, I did appellate work for years as a trial lawyer before coming over here at Martin and Gifford. So appellate work is something I'm very familiar with. We're nowhere near an appeal. Nowhere near it. Post-trial motions are first. Those are scheduled for March. And then once those are done, you can actually file the appeal. It's going to go to the Sixth Circuit. I think that's right. I didn't double check that. But anyway, I'm pretty sure it's the Sixth Circuit. Federal Court of Appeals. What are the chances? I don't know. I've told this in every time I've given this presentation, I've given this story, and I'll give it again. I was doing a trial in Johnston County, and I was getting hosed. I mean, me and my clients were just getting hosed every single step of the case. I felt like I was being treated unfairly. I felt like, with my appellate background, I knew the issues I was planting during the trial to win on appeal. I felt very good about my chances on appeal. And I was, I was just dead set. I mean, if you were to talk to me at that time, I would have sounded exactly like NAR's lawyers, where I'm just like, we are setting this up for appeal and we like our chances. And turned out I actually got a really good result in the trial, mostly because the trial lawyer, the part of the reason my life was so miserable in that case is because of the opposing counsel. I didn't like him very much. He probably didn't like me either. But anyway, I hosed him pretty good at trial, and it's because he overstepped and made a pretty critical mistake that hurt his credibility with the jury right in open court. And then I pretty much hammered on that till the end and got a pretty good judgment from my clients. Took that on appeal because I thought I could win all the way, and then lost. And that's the way appeals are. You just don't know. I've won appeals I thought I should lose. I've won appeals I thought I could win. I've lost appeals I thought I should win. And then I've lost appeals that I definitely knew I was going to lose prior to filing the brief. What are the chances here? I think NAR, I don't litigate antitrust cases. That is simply beyond my pay grade. I'm not even wearing a suit today, okay? Much less an expensive one. But the chances, just from someone who's somewhat familiar with this area of the law and appeals and stuff like that, I mean, yeah, I think they've got a chance. What are those chances? I don't know. I really don't. If you're looking at the political makeup of the Supreme Court, do I think it's favorable? Yeah. Does that mean anything? I don't know. There's actually an interesting case up there right now regarding regulatory. It's a really big regulatory case, and we'll see. I think that decision could also change my opinion on what their chances are. Timeline, forever and a day. I don't know. This could drag on for decades. They could settle it next week. There's really I have no idea. And the reason that that's important is because you have to think critically about what changes you may or may not make in your firm based on what you know now. Not based, and maybe you do it based on the chances of this succeeding on appeal. Maybe you don't. I can tell you that part of the reason we have buyer agency is because in the mid-90s, NAR lost a lawsuit regarding seller subagency. Seller subagency went away, we got buyer agency. So, is there going to be changes as a result of this? That's going to be up to you guys. So what can you do in the meantime? Like I said, talk to your lawyer about your firm commission policies. I think that is very important. Go ahead, do that. I'm not saying you got to change anything, but just have a discussion and ask your lawyers about it. I can tell you that the brokerages we represent that have reached out to us on this topic at my law firm, the answer's been different for everybody. And, for some people, we're just telling them, you're simply not a big enough fish to get wrapped into all this. You're not. You're a solo office. So the chances of you suffering one of these lawsuits is not good. You can make these changes if you want, certain changes, maybe changes to your policy, things like that. But, otherwise, your chances just aren't out there. Or we've told other people, yeah, these are things you need to tighten up. And especially Every client has a different tolerance for risk. Plain and simple. So the advice is going to be different for everybody. But these are things you need to talk to your lawyer about. Have real conversations with your sellers and your buyers about commissions and sell your value. And I think this is something the commercial brokers do better than residential. The MLS is very efficient and does what it's supposed to do pretty well. And sure, it's got flaws, whatever, blah, blah, blah. But at the end of the day, the MLS makes cooperating compensation something simple. And then if there's a problem with it, there's an arbitration process. My law firm also represents 13 local boards, smaller local boards, nothing as big as Canopy. But, so I'm involved with these ethics and arbitration disputes all the time. It is very efficient, given all the different factors. And in the commercial context, you guys negotiate your commissions a lot more. You have to, just because of the way it is. You don't have as many transactions as the MLS, so you have to do that. And I think that's an advantage for you guys, and probably one of the reasons why you haven't seen any of these lawsuits yet in the commercial context. Are you immune? No. And that brings me to bullet point 3 here. I've had enough conversations with commercial brokers so far that you guys, especially if residential brokers start moving into the commercial context, you need to be more careful about Section 2 violations, Standard Oil and AT&T. Don't be unlawfully exclusionary in how you approach the market. For example, don't refuse to do business with a broker just because they aren't usually a commercial broker. They're a residential broker. Don't have absolute rules about that. That will be you restraining the access to the market for other brokers like that will bring you under scrutiny under Section 2 and potentially also Section 1. So just understand that you guys aren't immune just because you do compensation differently. Other antitrust, risks exist out there for you guys. Just be aware of them and use common sense. And if you get into something really sticky, talk to your lawyer, or I'll give you some other resources in the next slide here. If you do residential, there's going to be forms changes. I don't know what those are going to be yet. We are working on them. We've already done a couple drafts. Nothing is set in stone yet, but look for those in the residential context. And we'll go from there. Resources for you guys on the NC Realtors website. There is an FAQ. You don't feel like you got to write down this link here. If you just go to ncrealtors.org and scroll all the way down to the bottom, you'll see the NAR, Burnett versus NAR. There's a little read more thing right there. And you can always call the NC Realtors legal hotline. As I said, my firm is general counsel to NC Realtors. If you call the hotline or email the hotline, either me or one of my 2 partners will respond to you most of the time, same day. It really, it's not guaranteed, but most of the time it's going to be the same day. I would say, if I had to guess, we have a success rate of getting to you same day about 90% of the time. The reason for that is mainly call volume. And the other reason is this, and this is something that I'm going to be harping on this year, and I'm going to start here with this presentation. This hotline is for realtors, okay? We don't talk to members of the public. We don't talk to brokers who aren't realtors. We talk to realtors. And the reason, and finally, you talk to a lawyer when you call this, and you're not just talking to some, guy who does wills and estates and then happens to do this on the side. This is almost exclusively what our firm does, okay? The reason I bring that up is because I have had a couple of very disturbing phone calls just in the last week of agents making decisions based on their discussions with people at the real estate commission. And the commission has a very specific focus, and that is consumer protection. They do not care about you. They don't. Their job is to train you. Their job is to hold you accountable. Their job is to protect the public. They are not there to try and help you navigate waters. They are there to do those things. And I don't have any problem with their purpose. I really don't. But there's more than one way to solve a problem almost always. And I think that in these 2 instances I am thinking of in particular, if the agents would have called the hotline, the realtor legal hotline first, they would have had a much different outcome. with their cases. One realtor gave up a commission entirely just because someone at the commission told him that that would be a good way to resolve it. I mean, you're talking about an agent who worked a long time in a listing and then ended up with zero money. And it was because somebody who has, a potential jurisdiction over his license that he felt like he had to do that. But, when he called me, I was like, no, you don't have to do that. There's other ways to solve this. And there's other ways you can take responsibility for this mistake you've made, which everybody makes mistakes. So it's not something that you have to, die on your sword on, like you have. I think, and the last thing about the commission is I don't even know if the person you talked to was a lawyer there. Their hotline, they do have one, but their hotline is not manned exclusively by attorneys. You may get someone who's just an investigation officer who may have a bachelor's degree or something like that. So I am encouraging, especially realtor members, to consider calling us first before the commission. In certain cases, not all cases, there'll be times you'll call, the realtor hotline, and I will tell you, hey, if I was in your position, I would want this from the horse's mouth before I take action, and then whatever they say, just do that. Okay. And sometimes I give that advice and sometimes that's appropriate. But if you want to talk to the commission, go ahead and talk to the commission. Just understand what their goal and purpose is. And if you want someone who's going to be more, I guess, focused on assisting you, then I think this is where you would go. Anyway, I appreciate you all having me here. And by the way, your staff and everybody involved with this organization is wonderful. I got sick last week and basically went completely incommunicado. I'm sure it drove them crazy. I appreciate their patience with putting this all together for you guys.
Great. Thanks so much, John. And we're going to click right along and turn it over to Michelle. And then I see there's some questions in the chat, so we'll try to get to those later, but we want to give enough time for Michelle to share with us her insights. Michelle?
Right, thank you. John, I think you need to stop sharing. Oh, no, I can go ahead and override you in just a minute.
I am an oversharer, though.
All right. Okay, everyone can see that, right? Yes, thumbs up.
Yes,
Okay.
we're all set.
All right, perfect. So, thank you, John, for that. That was great. I always like hearing about the litigation. We're watching it very carefully at Canopy. And considering there is absolutely nothing certain about where this is going to end up or how long it will take, the question then becomes, what's next? What do we all do in the meantime? So I'm going to focus for the next few minutes on that, and then we will open it up for questions. A lot of what I'm going to say is coming to you from a residential real estate perspective. And I know most of you watching this, or all of you, are commercial brokers, but as John said, the lawsuits themselves are focused on residential brokerage. But a lot of what I'm going to talk about is really applicable to all real estate practitioners. And it will give you a good idea of the types of things we on the residential side are dealing with right now as a direct result of all this litigation. So I'm going to start by talking a little bit about realtor membership in light of the verdict. There's been lots of questions around that. And then a bit about the buyer broker compensation rule itself. And then finally, what changes we, the Canopy Realtor Association and MLS, are considering at the local level. So to start, realtor membership. So we have started to get a number of calls from members asking us whether the verdict in the Burnett case means you no longer need to hold realtor membership. Surprisingly, quite a few of those calls have been from members more concerned about the sexual harassment lawsuit than the antitrust cases. And overall, we've actually had far fewer calls on the subject than we anticipated. But I'm fairly certain that number will probably go up. So on the question of realtor membership, we have our staff prepared to explain that the requirement of holding realtor membership has always been at the discretion of the broker in charge or the head of firm. We're a realtor-owned MLS, so we do currently require the head of firm to hold realtor membership in order to have that MLS access. But that head of firm has the option of whether or not to require their agents, their affiliated agents, to hold realtor membership. And then those non-realtors would still have access to the MLS as long as their head of firm continued to hold realtor membership. The downside of that for the head of firm is that the head of firm's dues are increased in a certain dollar amount for every non-realtor affiliated agent. And that comes directly from NAR and the NAR dues formula that's been around for a long time. And then that head of firm is also becomes personally responsible for any unethical acts of their non-realtor agents, which is likely why most heads of firm require their agents to hold realtor membership. But that option for realtor membership at the discretion of the head of firm is not new. But the second thing we let our members know when we're asked specifically about the effect of the verdict is that the verdict really has had no effect on the way realtor associations and MLSs operate yet. There's been no requirement that any of our rules have to change as a result of the verdict. But we at Canopy are exploring what changes we may want to make on our own in anticipation of what could happen, which I'm going to talk about more in a minute. And then finally, another one of the questions we get a lot is specifically about the settlement agreement entered into by RE/MAX and Anywhere and what effect that has on realtor membership. But we let them know that the settlement agreement, and as of yet, that's not final. It looks like it will become final, maybe in early May is what I'm hearing now. But that does not apply directly to our association or MLS jurisdiction. So the settlement agreement itself is between those entities and the plaintiffs. So right now, realtor membership is still required, again, by the head of firm in order for agents to have access to our MLS. Realtors nationwide are really beginning to question the importance of NAR and the importance of holding realtor membership. I've seen many comments from agents who want to separate themselves from an organization they believe hasn't done enough for them. At the local level, I've had calls from members that tell me NAR sold out the realtor, or they don't want to be part of an organization that does nothing for the membership. And frankly, NAR is not looking good right now. But one of the most important roles of NAR, and we are taking the opportunity to remind our members of, is NAR's involvement in advocating for federal policy that strengthens the ability of everyone to buy and sell real estate. So in looking at the NAR website recently, I actually found their active advocacy issues document, which I had not seen before. And it listed about 80 different issues affecting real estate markets nationwide. It tells specifically in that document how NAR is actively working on each issue, and they really are doing a lot in terms of advocacy for the industry. If you haven't seen that document or you're interested in seeing some of the things NAR is advocating for, I would encourage you to check that out. But then outside of advocacy, NAR does provide members with up-to-date housing statistics, market trends, the latest state and local area real estate data, detailed reports on commercial research, statistics and market data. And of course, there's educational opportunities and a variety of other tools to help members enhance their businesses. So we're trying to take those lemons and turn them into lemonade by taking the opportunity to educate our members a little bit on what else the national organization provides outside of a lot of litigation right now. But in addition to that, one of our main focuses this year at Canopy is helping our members demonstrate and explain to the consumer the value they bring to the real estate transaction. So these lawsuits, because of this buyer broker compensation rule John mentioned, really highlighted the need for consumer education on the role of a buyer agent, specifically all that they do, why they're needed, as well as the importance of that buyer agent to both buyers and sellers. And then, of course, the importance of consumers fully understanding how compensation works for both listing agents and buyers agents. NAR has been pushing since these lawsuits have been filed and gone to trial for states to create and implement the use of buyer agency agreement, which really sounds strange since we've had buyer agency agreements in North Carolina for years. We're actually one of only 12 states in the United States that currently have buyer agency agreements. South Carolina is also one of the 12. So what's actually foreign in many markets across the country is common in our area. But unfortunately, buyer agents haven't always done the best job in explaining their buyer agency agreements, in particular, how they're compensated and all that they're doing to earn that compensation. So we're stepping up our Realtor Value campaign in 24 to help realtors communicate their value to the consumer. We are advising realtors who already know this that they need to review the Working with Real Estate Agents document thoroughly. They should thoroughly review agency agreements right up front. And if you're a buyer agent, to not wait to discuss the agreement until you're ready to make an offer, which we know so many do. Both the North Carolina buyer agency agreement and the exclusive right to sell listing agreement have provisions dealing directly with compensation. So buyer agents, like listing agents, if they're not already doing so, they really need to walk through and fully explain those compensation provisions, explain to their clients what they're going to do in return for that compensation. And every agent, and I think John alluded to this, every agent, residential or commercial, should be making it clear commissions negotiable, which we know is going to be difficult for a lot of residential agents who've not had to have these discussions in the past. Commercial agents, they're mostly skilled at dealing with commission issues right up front. You handle commission differently. But this is going to be new for a lot of residential agents who really do need to get comfortable with having these conversations, especially in light of the fact that compensation through the MLS may disappear. All brokers need to be having discussions with their clients about who's getting paid, how they're getting paid, and how much they're getting paid. Compensation is, and it's going to continue to be, the heart of most of the lawsuits that are filed against NAR and these large brokerages, the MLSs, and now even realtor associations. So the Burnett trial examined in great detail what the plaintiff's attorneys referred to as the mandatory buyer broker compensation rule. So this mandatory rule has been adopted in some form by all realtor-owned MLSs across the country. And I've got Canopy's rule up here on the slide, and I'm going to read a little bit of it, but the rule itself states that by submitting a listing, the member participants making a blanket and unilateral offer of compensation to other MLS participants and shall specify on each listing the compensation being offered. So that's the mandatory language. They have to specify the compensation being offered. Our rule goes on to say that specifying the compensation is necessary because the cooperating brokerage has a right to know their compensation prior to trying to sell the property, and then that the listing brokerage retains the right to determine the amount of compensation offered to other member participants, which may be the same or different. So what's interesting is most, if not all, of the plaintiff's attorneys in these cases characterized in their complaints this mandatory commission rule as non-negotiable commissions, which are then rolled into the sales price of the home, driving up the price. And they've also stated that the rule makes competition on the buyer agent side pretty much non-existent. And that started with the first case, the Merrill case, which was filed in 2019. It's likely going to go to trial later this year. And that case is actually much larger than the Burnett case. So damages, if NAR were to lose, much greater. But despite the fact that the rule itself doesn't have a non-negotiable element, and we all know that commissions are negotiable between the broker and the client, it's not looking good for NAR or the MLS in terms of that offer of compensation. So in September of 23, we modified our MLS system to allow zero to be entered into the compensation fields. And I totally agree with John that, it's kind of ridiculous, $1 versus zero. Up until that time, our MLS actually allowed as little as 1 cent to be entered, but our system required a positive dollar amount. So we went ahead and we modified our system so that brokerages and agents can offer zero if they choose. But even with that change, we know we need to be proactive in determining what other changes might need to be made. So we, along with our leadership, are currently considering all of our options, whether that means making additional changes to our MLS rules, or separating, at least to some extent, from NAR's mandatory policies. So right now, we are looking carefully at whether we want to start allowing non-realtor access to the MLS, and this would be a huge change for us. So we're really looking at that from every angle possible. We have the code of ethics to consider, knowing that if we do allow non-realtors to join the MLS, the code wouldn't apply to them. So we're examining how we can potentially make some form of the realtor code of ethics enforceable through the MLS. We have to think about things like arbitration because it is efficient. We're also considering the issue of statewide forms, which right now are not available to non-realtors. And then, of course, we have to examine the financial implications on our realtor association if we were to make such a change. We're also examining what the MLS could look like if compensation became optional or if it was completely eliminated, which we feel is a very real possibility. So rather than wait for some court-ordered injunction to remove the compensation field, which could happen tomorrow for all we know, or NAR to mandate a new rule, we're going to take a proactive approach. We're investigating how our rules and regulations, our policy documents, our other MLS guidance, even our bylaws might need to be modified. We're looking at drafting what it might look like in this new world. Of course, if we move forward with making some of these types of changes, we know we're putting ourselves at risk of NAR pulling our association charter. So that's also a consideration, but we feel fairly confident that NAR has way too many other things to worry about than to come after us for changing the rules that are the subject of so much of this litigation. But it is a possibility. So we've got keeping that in mind. But even if compensation, which I believe is really a very small part of the MLS, even if that were to be removed, the overall value of the MLS system remains. I actually saw an article the other day about the future of the MLS and how the MLS could disappear as a result of all this. I don't believe that's going to happen. The MLS is far more than just a place realtors go to ensure compensation. Even without compensation, the MLS continues to be a marketplace for fairness. It is governed by a set of rules and regulations that ensure the MLS data is timely and accurate, which is just as important to consumers as it is to brokers and appraisers. Since the MLS is the source of all the data that powers brokerage and agent websites, mobile apps, and a host of other real estate websites consumers visit almost daily. So our plan at Canopy is to continue providing and adding tools to the MLS that help agents compete. Right now, our subscribers have access to a variety of tools that they can access directly through the MLS. And they have access to realist tax data, RPR, rate plug, courthouse retrieval systems, statistical tools, AVM tools, showing services, safety tools, list track, agent and consumer portals, which convey information directly from the MLS system to clients. And we have a builder's update that provides agents with a look at what's available in the way of new construction. And very soon, hopefully by the second quarter of this year, we're going to be adding Rental Beast, restb.ai, which is a really cool tool that uses artificial intelligence to do a variety of things. And down payment resource, which is going to get integrated into our MLS property listing data to identify eligible for sale properties. So we're constantly looking at ways to improve and add value to the MLS for our subscribers. And that's going to continue whether or not compensation remains a part of that tool. So in the meantime, as we watch all this play out, we're committed to not only helping our members explain their value and how important the realtor is to the transaction, but we're also keeping our eyes on the lawsuits, all that are pending, all that are being filed, so that we can keep our members informed how they can better prepare themselves for change. Because the fact is, the real estate industry is changing. It's changing fast, and we need to be prepared to operate in an industry that may look very different very soon. So that's all I have. If we want to open it up for questions.
Thank you so much, Michelle and John. Yeah, we have a couple questions in the chat. One is regarding compensation. Can a company have a policy on what the firm charges? All listings belong to the firm, versus the individual agent. The firm being whoever the broker in charge is.
Yeah, like I said, that's not something I'm going to give specific advice about today. I don't think it would be appropriate, honestly, and may make things worse for everybody. I would say this, that's something you definitely talk to your personal attorney about. Um, to me, it makes sense, to have, like, firm rules and then rules for agents, if any, and having those two things be separate as far as what you can or cannot do or should or should not do. That's beyond the scope of what I can do today.
Okay. Michelle, any thoughts on that one?
I think John covered that, and I think that's some
Okay.
good advice.
All right, next question is, do you see this case setting a precedent for the current commission structure that we see? For example, seller buys, pay or rep commissions in general to be a problem?
Setting a precedent, I think, is difficult at this point. We're talking about a trial court verdict, and the reason we're talking about it is because of the size of it, right? And for me, from a lawyer perspective, we haven't been sued yet. And so every day that we can try and enact changes, then what that does is essentially stop the clock. If we change nothing, the clock just keeps running. And what happens is if one of these cases is filed, whenever it's filed, you take that date, and then they are going to look back 4 years. Okay. Now, if you make changes now and stop the clock, then that means if they file later, they can say, let's say they file 6 months from now, they can look back 3.5 years or something like that. Nothing is going to be bulletproof one way or another. It may well be you could make all sorts of changes and still end up being the subject of one of these suits. And I'm glad Michelle actually brought up the other, today I focused on the seller side, but yeah, the buyer side is the same thing. These buyers are saying, I had a contract with you, buyer agent, and then I ended up paying more money because you got more money through the cooperative compensation than what I was willing to sell, but that money came from me, right? And we had an agreement. Yeah, but those cases are big. But part of the reason those buyer agent cases are bigger is because they want to go back forever and not just 4 years. So them being able to do that, I don't know. That seems like a stretch to me. But to say and I'm not meaning to take issue with the question itself, but to say it's a precedent, I am uncomfortable with. I think this is important information, and that's why I sort of want to leave it with, here's the information, talk to whoever your counsel is to see if you need to make changes or not. I'm not looking to upend an entire industry about a jury verdict that may be turned over in a couple of years. It makes no sense, especially when, in my experience, I've been doing the legal hotline for realtors now for 8 years. I think I'm coming on 9 years now. 9 years. This year will be 9 years. I mean, you guys are not out there trying to do anything but look out for your clients, except for a few bad apples. I mean, it's like lawyers. There's a couple of us are just these blood-sucking idiots, and then look what the reputation we get. And you guys suffer sort of the same thing. So maybe you should be nicer to lawyers going forward. That's going to be my advice today. Anyway, I'm just saying that in my experience with realtors, you guys aren't doing anything except looking out for your clients. You want to be paid fairly for the work that you do. And so to have like a case like this come out where you're relying on a system in good faith, and then somehow the system is blamed and you just get roped into it, it is jarring. It seems very unfair, and I sympathize with all of that. I really do. And so I guess what I would say is this. Does this set a precedent? No. Is it a good opportunity to re-examine some of your business practices? Yes, 100%. Do that.
Okay, and then Cindy points out, wow, if a seller pays a buyer, wait a minute, let me see if I can get this right. If a seller pays a buyer or tenant rep, then the buyer or tenant rep can file a commercial broker lien. And then someone else points out, if Canopy allows non-licensed people on and does not help disclose compensation, there's no value in staying a member. I can go on Zillow. So I think there's a lot of confusion because it's, licensed brokers versus non-licensed brokers. And then you have the differing structures for both residential, which is, Canopy multiple listing service, which is a known entity. And then you have Zillow on the residential side. And on the commercial side, we have even more choices, right? And we have CoStar LoopNet, we have Catalyst, there's Crexi. So how do we guide the commercial real estate industry in terms of these issues as it relates to the tools that we use in commercial?
So I want to jump in and kind of address Gina's question.
Yeah.
So Canopy, I just want to make sure it's clear. We would never allow a non-licensed individual into the MLS. So it's not non-licensed. It's a non-realtor, basically, someone who's not a realtor, hasn't joined a realtor association. They do still need to have a real estate license. And as far as going on Zillow, I mean, yeah, of course, everyone can go on Zillow. Zillow doesn't have the integrated tools that the MLS has. So there is value in the MLS. So I want to make sure there's no misperception of what we're considering. I do think there is value of the MLS. I also agree there's value of the code of ethics, and again, peppering that into the MLS in some form to keep the real estate agent, at least the MLS agents, held to that higher standard that realtors are currently, if we do allow non-realtors, licensed, but not a realtor. So I wanted to touch on that.
I will add this to that, and I think Michelle touched on this already. If you're asking me to rank realtor member benefits, MLS would be maybe top 5, but it's not even in the top 3 in my view. And that's just my opinion. No slam on you, Michelle. Sorry. No, I do think there's value in the MLS, but let me just tell you that the number one thing that realtor dues do is make sure that the industry is not overrun or impeded by political objectives. One of the things that I do for NC Realtors is work with the lobbyists, with the local GADs, governmental affair directors. You guys have a local one down there, and review legislation, and when bad legislation comes up, to work with our allies to make sure it doesn't get out there. The fact that you would have a commercial broker lien statute is because that's what membership asked for. And then we went out and got it. I mean, I don't think I can fully explain to you in a matter of, the limited time I have here, of how often there are outside forces, especially in the political arena, that if they were allowed to go unchallenged, and I'm not saying all regulation is bad. I am not like that. I was the mayor of Clements for 4 years. Okay. I believe in government regulation to a degree. All right. I'm not saying that, but there are people out there who, if they were going to do what they were going to do unchecked, without input from this organization, your entire industry would look much different. It would be much harder to do the things that you do, and especially in development, commercial. You guys deal with local politicians all the time. There is one entity, Neighbors Helping North Carolina. All they do is support local candidates to help you guys make sure that you can do smart development, and that these NIMBY people who wouldn't build a single thing ever, they would vote against every single development that ever came before them, that those candidates are opposed, or that their true views are known. If that's what the community wants to vote for, fine. There's not much we can do about that. But I mean, if you're asking me to rank realtor member benefits, that'd be number 1. And the same thing goes for the national level. It'd be the same argument, just on a much bigger scale. And so what I would tell you is that, fine, the MLS doesn't have value for you, but if your day to day, you know, especially you guys being commercial brokers, and I understand you might not think the MLS is that, you know, to you it's not that important. These other things are extremely important. And I think that, you know, those things cannot be overstated. And I'll give this as just a final example, just to make it a little bit more real. You know, there was a property manager who called, and basically the sheriff was telling him that if he didn't come get the tenant's dogs, the tenant just got evicted. If he didn't come get the tenant's dogs, then he was going to be prosecuted for cruelty to animals. Okay. You're talking about the sheriff putting pressure on a member, a realtor member, you know, threatening them potentially with criminal prosecution if they don't do something they have no obligation under the law to do. That's the tenant's personal property they left behind. I know if you got fur babies, I'm not trying to disparage fur babies, but I'm just saying, technically under the law, pets are personal property. And, you know, basically what happened in that case was the member reached out to me. I put him in touch with the lobbyists, that way all the way to the Representative General Assembly, who then came back down on the sheriff, and suddenly the problem went away. That is the kind of things that we can do with the resources that we have from you, the membership. And we're talking about selling value. I
Yeah.
think that is one of the things that is, you know,
Yeah.
there's no
Well,
bigger.
you make a good point, and Cindy in the chat, and we're out of time, unfortunately, but she's mentioning sales tax on services, call to action on the huge insurance increase proposed. So it's all the more reason, I think, for both residential and commercial members alike to pay attention to legislative issues, you know, and fund the political action committees for the state you know, the state PACs and the RPAC, et cetera, because there's a lot of issues that are affecting us, and it's kind of hard to address them after the cat is out of the bag, so to speak, and address these. So thank you again so much, John and Michelle, for your insights. Lots of stuff to unpack here, and I think it might be good for let us know, and let your folks at TCAR and CRCBR know if you want to have continued dialogue on legislative and legal issues, because I think it's important, because it affects us certainly in the commercial real estate industry as well. So with that, thank you all for coming, and thank you both, and have a great afternoon.
Bye.